Hi, everybody. Today's How to Read Legalese video is all about power of attorneys. So a lot of people have this estate planning document, and I do have other YouTube videos that explain in more detail what the power of attorney does. And maybe just to sum that up real quickly before we dive into today's presentation, the purpose of a power of attorney is to grant someone the authority to help you manage your assets or make any legal or financial decisions on your behalf. It does not cover making medical decisions. It's solely in regards to, again, most commonly we see it just in financial transactions. So the ability to access somebody's bank accounts, pay bills, file tax returns, and such. But to dive right into the presentation for today, as per usual with these Reading Legalese presentations, we're going to start off with the key terms. First one you're going to want to know is the principal. That's the person whose power of attorney that it is. The agent is the person that the principal has appointed to be able to have that authority to access the principal's assets, like I mentioned in brief summary again of what the power of attorney does. The agent is also sometimes referred to as the attorney in fact. In 2016, Connecticut enacted an entirely new set of power of attorney laws, which changed several things, one of which being that terminology. So pre-2016 form powers of attorney will say you've appointed an attorney in fact. Post-2016 powers of attorney are usually going to say you've appointed an agent. It's the same person, it's the same job. It's just the terminology changed under Connecticut statute. What is a durable power of attorney? That's a question I get really commonly. And durable simply means that your power of attorney is going to be effective. If you're the principal, it's your power of attorney. Your power of attorney is still going to be effective even in the event you become incapacitated. I know it sounds kind of counterintuitive that you have to clarify that, but the default rules pre-2016 was that unless a power of attorney said that the power of attorney was durable, the presumption was that it was not. So you had to specifically say this is a durable power of attorney in order for it to still be effective if you became incapacitated. When those new power of attorney laws in Connecticut came in 2016, the statute reversed that. So they said the presumption is now that all powers of attorney are durable unless you specifically say you don't want it to be durable. So even if you don't see the word durable on your power of attorney, the law says it is, because again, that's going to be the new default. And that's going to be true even if it's a power of attorney that was signed pre-2016, because the law applies retroactively. So it's still going to cover those pre-2016 powers of attorney. Other key terms, jointly and severally. When you're appointing two agents to serve together under your power of attorney, you have to choose how you're going to have them serve. And those are the two options. You can have them serve jointly, or you can have them serve severally. If you appoint your agents to serve jointly, I always tell people to picture like you've handcuffed your two agents together, because that's how they have to act. They have to act together in all things. They both have to agree. They both have to sign off on everything. That's what it means to serve jointly. If you say you want your agents to serve severally, that means they both still have the authority to act for you, but they can act independently of each other. So if only one person can sign off on the check, or if only one person can go to the bank that day, that one agent has the power to act on behalf of both the agents. And also to clarify too, when I say appointing two agents, I don't mean I appoint my spouse first, I appoint my son second. That's you still have appointed independent agents just in succession. So if one person can't do it, you have a backup. The situation I'm referring to here is if you say, I appoint my spouse and my son to serve together as agents. So when you have two people serving at the same time, that's when you're going to clarify whether you want those agents to serve jointly or severally. Last key terms here, long form versus short form statutory form power of attorney. Because as the name implies, these are documents that were created by statute. So under the statute, there is a long form that the legislature has created, a long form power of attorney. There's also a short form power of attorney. And as you might guess from the names, the long form power of attorney just simply includes some additional powers, an additional grant of authority that isn't included under the short form power of attorney. So some key provisions. So number one, look to see who is appointed, who is the agent. A lot of times it's just choose your primary agent. But the forms that we prepare, we always recommend that you also have a successor agent. So just in case your first choice can't serve, who's that alternate agent going to be? And a lot of times it's right on the front page, so you don't have to go hunting for that information. We make it really easy to find. Also, the effective date of the power of attorney. And this can sometimes be towards the end of the power of attorney, back towards where the signature line is. And typically powers of attorney are going to be effective immediately. So you as the principal do not actually need to be incapacitated in order for your power of attorney to be effective. Again, typically it's effective immediately from the moment you sign it. So just be aware of that as well. And that will usually, again, be printed out in big bold letters, say this power of attorney is effective immediately. And again, typically towards the back of the form. Also, the next big piece of it is the powers that are actually granted to the power of attorney, to the agent under the power of attorney form. And we are very clear about what the authority, or I should say, it's very important to spell out what the authority it is that's being granted to the agent. So if they go out and try to use your power of attorney and they give it to a bank or a financial institution, that bank or financial institution is going to know whether or not the person, that agent, is actually authorized to do what they're trying to do. So to show you just an example of what the forms look like, the statutory forms look like in terms of the powers that are typically listed out. This is from the statutory short form power of attorney. So that those paragraphs A through N are the standard powers that are granted to the agent. And they're really broad general powers, but also all encompassing to, again, really making sure your agent is going to have all the authority that they need to do what needs to be done on your behalf. So they can deal with real estate and stocks and bonds and banks, taxes. So those are the typical short form powers of attorney that you're going to see. And both, while I say it's the short form powers of attorney, you're going to see those same powers in the long form. But in the short form, that's kind of the entire list of powers being granted. Well, under the long form, you're going to get those paragraphs A through N, but then you're also going to get these additional estate planning powers, or sometimes they're referred to as hot powers. And it's just, again, additional grants of authority that you're giving over to your agent. So not only can they just generally deal with banking transaction and real estate transaction and taxes, but they can also create estate planning documents for you, like trusts. They can make gifts of your assets on your behalf, including maybe even making gifts to themselves. They can change beneficiary designations on life insurance policies and retirement accounts. So again, it's just a little bit of a broader scope grant of authority. So that's typically, again, if you're looking at your document, it'll probably say right up the very top of the first page, whether it's a short form or a long form. And again, if it's a long form, you're just likely going to have a more expansive list of authority that's actually being granted to your agent. You should also note that, and you can see actually in the language here from the long form statutory power of attorney, is that these hot powers, these additional estate planning powers, you as the principal actually have to put your initials next to each one to say, yes, I actually do want my agent to be able to have these powers. And the reason why the legislature crafted the form like that is, again, because you're giving over a lot of authority here. So they want to make sure you actually read through the language. Yes, this is intentional, that you're actually giving your agent these powers. So if you see a long form power of attorney, but it has those, again, parentheses next to all those powers, but they're not initialed by the principal, that means even though those powers are there, the agent doesn't have them unless the principal actually proactively put their initials next to each one of those powers. So that's how to read powers of attorney. If there's any other questions, please feel free to visit our YouTube channel to get other videos about, again, more in depth what the power of attorney does. And maybe if you have any additional questions, you can also contact us directly. So please always feel free to go to our website to get our contact information and reach out with any additional questions.